In this video, we will discuss the differences between but-for and substantial factor causation. And these are really just two types of tests that many courts use to determine whether a defendant caused damage or injury. So let's say we have a defendant here, and he takes an axe to a tree which is right next to a car. The defendant foolishly chops down the tree, damaging the plaintiff's car. Well, in our lawsuit, the plaintiff is going to have to prove that the defendant caused the damage to his car. And this is also a good example of but-for causation, meaning if the defendant had not taken the axe to the tree, let's say he just decided to make a phone call instead, the car would be just fine. The tree would not have fallen on the car. A jury is likely to conclude that but for the defendant's actions, the car would not have been damaged. For that same reason, a jury should conclude that the defendant was responsible for causing the damage to plaintiff's car. On the other hand, let's say we have a plaintiff who has a bad back, and he wants to sue his employer who he says forced him to carry these big boxes. But the plaintiff also played football, and he enjoyed lifting weights. So was the bad back caused by lifting boxes, playing football, or lifting weights? Maybe all of these factors had a role in causing the injury. So of course our employer will say, look, even if he hadn't lifted the boxes, he still would have ended up with a bad back. So we can't say that but for the boxes, he wouldn't have been injured, therefore the employer didn't cause the injury. The plaintiff might not be able to prove but for causation. However, he might be able to prove that lifting the boxes was a substantial factor in causing his injury. The defendant can bring evidence that lifting the boxes was at the least a substantial reason why he was injured. The court will require proof as to how lifting the boxes was a substantial factor. Looking at another example, let's say lightning causes a forest fire, and our defendant for some reason decides to throw a can of gasoline into the fire, and eventually the forest fire destroys plaintiff's house. Well, the gasoline must have contributed at least a bit to the forest fire, but even if he hadn't thrown the gasoline, the forest fire would probably have destroyed the house. In this situation, we might not have but for or substantial factor causation. The house would have burned down even if defendant didn't throw the gasoline, so we don't have but for causation. And the gasoline really didn't contribute to the forest fire, so we can't say that defendant's action was a substantial factor in causing the damage to the house. If you'd like to discuss causation or any other matter related to U.S. law, stop by my website and blog, and feel free to submit your comments below.